If the insurance company scheduled an IME in your workers' compensation case, this is the moment everything can change. An independent medical examination sounds routine. It is not. Sandra's husband, Darnell, hurt his back unloading trucks at a UPS facility in Cicero. 6 weeks into his claim, a letter arrived scheduling him for the IME. Sandra Googled it at midnight, and now she's scared. She should be. That doctor does not work for Darnell. I'm Mark Connolly, a Chicago workers' comp attorney, and here's what that letter actually means. If you received a letter scheduling you for an independent medical examination, or if your spouse or partner just got one, I want you to hear this clearly. The IME is not what it sounds like. The word independent is doing a lot of heavy lifting in that name, and it does not mean what the insurance company wants you to think it means. What an IME actually is, an IME is a medical examination scheduled and paid for by the insurance company. The doctor performing the exam is scheduled by the insurance company. The doctor is paid by the insurance company. The doctor's report goes directly to the insurance company. This doctor is not your physician. They're not there to treat you, advise you, or act in your interest. Under the Illinois Workers' Compensation Act, the employer and insurance carrier do not have the right, or they do have the right to require an IME. That right is spelled out in the statute. You're generally required to attend it. If you refuse or fail to appear without a valid reason, your benefits can be suspended. So you have to go, but you need to understand exactly what you're walking into before you get there. What the IME doctor is looking for. His job is not to treat you. Their job is to evaluate you and write a report. That report will address several things. Whether your injury is consistent with the mechanism you describe, whether your current medical condition is related to the work injury or is some pre-existing condition, whether you need continued medical treatment, and often whether you're capable of returning to work. Here's the dynamic you need to understand. IME doctors are not paid by seeing patients the way your treating physician is. They're paid to perform evaluations. Many of them do a significant volume of evaluations for insurance carriers. That is their business model. And their reports, taken together over time, tend to come out in favor of the side that is paying them. Studies of IME outcomes consistently show that IME doctors find workers to be at maximum medical improvement, capable of returning to work or suffering from pre-existing conditions at significantly higher rates than treating physicians find in the same patients. This is not a conspiracy. It's an economic reality. Understand it for what it is. What happens after the IME report lands? After the exam, the IME doctor writes a report and sends it to the insurance company. What happens next depends on what that report says, and it can go several directions. If the report says you can return to work, the insurance company may use it to cut off your TTD benefits. Your checks stop. If the report says your condition's pre-existing and not related to the work injury, the insurance company may deny or reduce your claim entirely. If the report says you've reached maximum medical improvement, meaning the doctor believes further treatment will not improve your condition, the insurance company may use it to stop covering ongoing medical care or to push for settlement at a number that does not account for your future medical needs. In each of these scenarios, the IME report becomes the insurance company's documented justification for a decision that directly hurts your claim. This is why the IME matters so much. It's not a neutral event. It's a strategic move by the other side. What to do before the IME appointment? First and most important, call an attorney. If you've not spoken with a workers' comp attorney and you just received an IME notice, that notice is your signal. Do not wait until after the exam. Call before the appointment. Second, make sure your treating physician has thoroughly documented your current condition. Before the IME, go see your own doctor. Make sure everything is in your medical record. Every symptom, every limitation, every activity that causes pain, your sleep disruption, your functional restrictions. The IME doctor will compare what you tell him at the exam to what is documented in your chart. Gaps between what you say and what your records show will be used against you. Third, be consistent and accurate at the exam itself. When you attend the IME, tell the truth. Describe your symptoms honestly and completely. Do not minimize them because you want to seem tough. Do not exaggerate them hoping for a better outcome. If your back hurts when you bend a certain way, say so. If you can't stand for more than 20 minutes without pain, say so. If a specific movement caused you to stop what you're doing, say so. One more thing to know. The IME doctor will be observing you from the moment you arrive, potentially including the waiting room and the parking lot. People have their claims hurt by what happened before they even walked into the examination room. Be consistent from the moment you arrive to the moment you leave. Fourth, write down everything that happened in the exam as soon as you leave the building. How long did the exam last? What parts of your body did they examine? What questions did they ask and what did you say? What did the doctor say to you, if anything? Write all of it down while it's fresh. Your attorney will need this information if there's ever a dispute about what the doctor actually did or documented. What to do if the report goes against you. A negative IME report is not the end of your case, not by a long shot. Under Illinois workers' compensation law, IME reports can be and regularly are challenged. Your treating physician's opinions carry significant weight before the Illinois Workers' Compensation Commission, the IWCC. Arbitrators at the IWCC evaluate both the IME report and the treating physician's records, opinions, and testimony. They are experienced with the IME dynamic and they weigh it accordingly. The process for contesting a negative IME outcome involves filing an application for adjustment of claim with the IWCC and proceeding to an arbitration hearing where you present your medical evidence through your treating physician and make arguments for why the IME doctor's conclusions are not accurate or not supported by a full review of the medical record. Workers win these disputes regularly, but the foundation for winning is built before the exam, not after. A strong treating physician relationship, thorough medical documentation, and an experienced attorney who knows how to present this evidence at the IWCC are the factors that turn a negative IME into a winnable fight. The bottom line, if you received an IME notice, you're at a decision point. The insurance company has made a move. What you do in the next few days matters more than what you do after that exam. Call an attorney before your appointment if you possibly can. The consultation is free. The information is critical. And in my experience, the workers who fare worst in the IME process are the ones who walked in without understanding what was happening. Do not be that worker. If you've not watched the foundational video on how Illinois workers' comp works, that's the next thing to watch. It covers the no-fault system, your medical rights, and what your employer is not telling you. Don't miss what we're releasing every week. And if you need to talk before the IME, Connolly and Gillette offers free consultations. Do not go in blind.